So, good morning, everyone, and welcome to yet another edition of SMS, the Saturday morning sessions or the Saturday morning satsang, I would like to call them. But I'm sure, like me, you will also reciprocate the feeling that we are all adding value to our thoughts on GST because of attending these sessions, because these sessions are being taken by none other than our own family members, GST faculty family members. So, they are faculty in their own right for the last 8 years since GST is into implementation. So, I've at least gained a lot of thoughts from here, which I'm also using sometimes in my pleadings during the court and during the arguments also in different forums. So, with this today, we are fortunate to have C. Annapurna Kabra ma'am, all the way from the wonderful city of Bangalore. So she's practicing there as a chartered accountant, and she has many feathers to her cap, apart from writing wonderful books on GST appeal. So with this brief introduction, I would like to also share about the topic today. But for that, I would invite CA Dr. Arpit Haldia ji to kindly, an advocate, sorry, and the Arpit Haldia ji to kindly enumerate on the topic today to be discussed. Arpit ji, over to you.
Thank you, Roopji, and a very good morning to all. And today we would be starting discussion primarily focusing on armor securities, but also extending to the legislative background and how Section 6 was incorporated in the statute and what was the intent and how the things progressed up till and until armor and how armor has sought to redefine the entire space in my opinion, and Annapurna Kabra ma'am would be deliberating in detail. This is one of the landmark judgment which would be setting down the fields. It would be incorrect to say that this is the end of the litigation. In my opinion, this is the starting, and further more judgment would be coming and deliberating on each and every aspect in detail about the scrutiny, audit, and investigation, and someone and how, with respect to armor, they have to be understood. And it is indeed a pleasure that Annapurna Kabra ma'am herself volunteered to take this subject and discuss out the details and the nitty gritties on this subject. And she has been preparing for this subject for the last 2 to 3 weeks and has been going in detail. So it would be an absolute pleasure to host her on the platform of GST faculty and hear her thoughts on this issue and ask all the faculty members also on joining in the session to share their views on whatever issues which are being raised by ma'am. And I have a pleasure to go through the PowerPoint presentation of ma'am, and she had detailed out in two parts. One is the discussion, and second, she would also be taking the case studies. So this is the brief background that how she intend to process, and whatever are the queries, most of them would be covered in the case studies also, and these case studies are thought provoking. So we would be having a detailed discussion, and already we have put a 2 session timeline for this topic, which may extend in to third also. So looking forward to your deliberation, ma'am, and with this brief background for 3 sessions. So in my opinion, this background would be going on to 3 sessions. So I took a little more time to explain the background. So handing over session back to Arup and then to ma'am.
Yeah, thank you, Arpit ji, and I think you have wonderfully summarized and also shared that इसमें 3 sessions लगेंगे, maybe, but I think yeah, that will be depending on the time available with ma'am. So, ma'am, over to you for Bahubali. I think Bahubali of litigation, part one. So, over to you, ma'am, with armor security.
Thank you so much. Thank you, Arupit sir, for kind words. Thank you, Arup sir, and thank you all the mentors and members for joining this session. And I've already written this is for discussion purpose. So we have just tried to go into the flow of this decision. And we have already seen from last 7 to 8 years, we are able to see that we are receiving many notices, many from the multiple jurisdiction. And I think we have always been litigating on the jurisdiction. So this decision will try to understand from the perspective of the principles of law, what is it has analyzed Section 6 in detail, and it has given a different perspective. So I think we'll get more practical perspective when we are going to discuss on the case studies. And being a Supreme Court decision, I thought we'll give all the contentions which are taken by the appellant and as well as by the respondent, and we'll try to analyze, and accordingly we'll discuss from the different perspective also. With that, once again, special thanks to Arpit sir for guiding me on this presentation, and hope to get all the further suggestions on this presentation, sir. And with this, I'll initiate the discussion. So the first very important term, which was I was just trying to look into the reference of cross empowerment, so that I'll just look into that aspect detail. But before going into that, we have to have what is the background of administration under the GST law. So as we are all are aware that both the central authorities and the state authorities are given an authorization to enforce the GST laws. So both the officers are having their own powers to administer the GST law. And cross empowerment is allowing the officers, because of cross empowerment, both the central and state authorities are acting as a proper officer for administration of that. But the issue is there are a lot of conflicting judgments which we are able to see from last 6 to 7 years. Because of that, there are a lot of critical issues which are arising from that. And I think we have to see how the conflicting judgments are there. And there is a few judgments still which is pending before the Supreme Court, like TVL Vardhaman, and that is a decision which is pending, where they said notification is not is required, whereas Pinnacle judgment of Kerala High Court has said it is notification is not required. So there are various aspects of still on this Section 6 which is pending before the court. But we'll try to analyze in this decision how they have looked into the aspect of Section 6 as such. And before going into this constitutional amendment, we have to try to look, is there anything they have discussed on this cross empowerment in Constitutional Amendment Act also? As such, they have not discussed whether it is in Article 246A or 269 or 279. They have not discussed on this aspect, but they have tried to give in Article 246A, which I said, notwithstanding anything contained in Article 246, both the central government and the state government have the power to levy the GST. So that power is there, that simultaneous legislative power is given, but they are silent on this cross empowerment. And before going into this Section 6, we have Section 3, Section 4, Section 5. Basically, Section 3 and Section 4 is dealing with this appointment of officers. Section 3 is the appointment of officers by the government, that is class of officers. Section 4 is also specific pertaining to the appointment of officers, and Section 5 is also giving the functions and powers of the of proper officers under the respective act, that is Section 5 of the Central GST Act or Section 5 of the KGST Act. So that is a quite, to some extent, it is clear on this linear jurisdiction. So that is quite specific notification circulars are there under the respective section. But the major issues we are having in Section 6 as such. So this is the background before going into the Section 6 of the GST Act. Anybody want to discuss on this, any aspect? We can add it regarding this constitutionality or any other aspect we can. Otherwise, we'll proceed with Section 6. So shall I proceed?
Yeah, ma'am, I think we can proceed. Yeah.
Yes. Yeah, so this is something where we have to look into this Section 6. The more we are reading this section, the more thought process we are getting actually with this reading of the section, though it looks little simple in the first reading, but every word, every comma, or every term has been analyzed in this decision more or less. So Section 6, subsection 1, just for our reference, I'm trying to read this section because generally we don't read this section multiple times. So what are the aspects which they have discussed in this? We'll just go through before reading. So I'll just read in 1 minute. So Section 6, subsection 1 says, without prejudice to the provisions of this Act, the officers appointed under the SGST Act or UGST Act are authorized to be the proper officer for the purpose of this Act, subject to such conditions as the government shall, on the recommendation of the Council, by notification specify. So this is a first Section 6, subsection 1, which has given the power, saying that if the officer is appointed under the SGST Act, he is deemed to be a proper officer for administrating the central GST law also. So he is authorized to be a proper officer for other act also. And subject to the conditions specified in the notification under subsection 1, where any proper officer issues an order under this Act, he shall also issue an order under the SGST Act as authorized by the SGST Act or UGST Act, as the case may be, under the intimation to the jurisdictional officer of state tax or union territory tax. Section 2, subsection B also says that where a proper officer under the SGST Act has initiated any proceedings on a subject matter, no proceeding shall be initiated by the proper officer under this Act on the same subject matter. So this is the most important section which has been discussed in this armor, section 6, subsection 2, A and B. And section 6, subsection 3 also says that any proceedings for rectification, appeal, and revisions, wherever applicable, of any order passed by an officer appointed under this Act shall not lie before an officer appointed under the SGST Act or the UGST Act. So this is the brief background of this section. This is a drafting of this section. So let us try to analyze how it has been looked into in armor decision. So before going into this armor decision, I was just trying to analyze. There are few council meetings which has been discussed in the decision. There are few circulars also which has been
Anupama
referred.
ma'am,
Yeah,
I'm just interrupting. I think Padmaji has put a question.
yeah.
The section 6(1) under the State GST Act, does it refer only to state tax officer of the state in which RP is registered?
Ma'am,
I
if you
couldn't.
could just take back that previous slide, I just
Yes, sir.
have one
Yes,
small point. Maybe it will be helpful for all. That's why I just
yes,
wanted to
yes, sir.
discuss this
Yes, sir.
issue.
Please, please, sir. Section
Next one, ma'am.
41.
Next one.
Okay.
Section 6.
Sir. Ha,
So
Padma.
section 6(1) says the officer appointed under the State GST Act or the Union Territory are authorized to be proper officer for the purpose of this act.
Yeah.
So suppose I am registered in the state of Kerala.
Hmm.
Does a state tax officer appointed under the Tamil Nadu State GST and Act also assumes power under 6(1)? Because does the word the State GST Act means all the State GST Act or only the state in which I am registered? That is basically my point.
Okay. To my
Especially in light of all these summons that are being issued by
yes.
officers of different other states.
Yeah.
So will they assume jurisdiction under 6(1) is my doubt. That's all.
No, my reading is it will be only under the respective jurisdiction, that is respective state act. It cannot be the Tamil Nadu or the other state. It will be under the Kerala jurisdiction.
Correct. That is also my understanding, especially with the word the being present
Yeah.
before the
The
state GST
officers
Act.
appointed. Yes, yes,
Yes. The state GST. So it
yes,
refers to a particular state. That is what I also believe.
yes, yes. I agree with you.
Thank you.
But when some goods are moving from one state to the other, and the initiation is done by the jurisdictional officer of another state, I mean the SGST of another state, will that have a bearing on this? Can we raise an objection? I don't think we can raise an objection.
No, we cannot raise the objection because he will be the jurisdictional officer of that state actually, where the inspection or this investigation has happened under 129. That state will have the jurisdiction to look into the aspect of e-way bill. Only this power is given in the case of e-way bill. If you see that respective state where the investigation has happened, that officer will become a jurisdictional officer for conducting the
But is
investigation.
there any specific provision for that, ma'am? Because I think we can challenge that because nobody has thought about this. Is there any specific provision for that?
Because I was reading the respective, every state has their own way of looking into that specific, because every state have their based on monetary limit and based on other powers, they have their own notification and circulars. But in the circular which has been given under this for the proper officer for MOV 1, 2, 3, where I was just trying to read into that. So they are trying to give the jurisdictional aspect of that respective state only in that circular 48 bar 2018, I think. That was a
Yes.
circular and yeah.
And
But
this is also
can
challenged. But
can
Yeah.
Padma, this is
jurisdiction
also
be
challenged.
conferred through a circular?
Yeah, I agree. Even there are, I'll be discussing the future circulars also, where we can look into that, whether it can be based on circular, can they analyze and conclude on this jurisdictional aspect. But in the case of e-way bill, to the extent what I understood from that circular and this reading of 129, they have the jurisdiction in that respective state itself to look into those investigation matter. So, for example, if I am registered in Karnataka and if my vehicle is catched in Gujarat jurisdiction, then that Gujarat state will have that jurisdiction to look into this investigation, though I am registered in Karnataka. So, I think that is what is given in that circular itself.
Ma'am, just adding on to the point of Padmanathan ji that the reference to state officer in section 6. So, if we go by the object of CGST Act and preamble which says It is an act to make provision for levy and collection of tax on intrastate supply of goods or services of both by central government and for matters connected therewith or incidental thereto.
Yeah.
It's an act for an intrastate supply. So
Hmm.
whenever Section 6 is referring to the state or the UTGST officer, it is referring to the corresponding act of the state which is levying tax on intrastate supply. So for the purpose of proceeding, we would have to see the state with reference to the intrastate supply on which the CGST is levying and the corresponding act of the state for the levy of tax on intrastate supply. Secondly, regarding the summons being issued from other states. So, summons being issued. So again, although this is a topic which you will be taking subsequently, so Section 6(1) is saying about proceedings, where the summons are being issued for the conduct of the inquiry, which are being issued under Section 70. So the summons would not be falling within the scope of Section 6(1). Had they been falling under 6(1), and Supreme Court or any of the court would have been equated proceedings equivalent to the inquiry, then in my opinion, they could not have issued the summon. And when they are issuing the summon, they would be carrying out an inquiry for the case which they have in hand. They cannot carry out an inquiry for a dealer who is registered in another state, and that's why DGJ is issuing summon for the entire country, because they have been given the power to issue the summon. And regarding the levy of tax while the goods are in movement and in IGST, so when the goods are in movement, since they are in the course of interstate movement from one state to another, so IGST is applicable. And since IGST is applicable, whenever the goods are being detained in a state, that's why those respective officers are issuing us temporary registration of that state so that they can acquire the jurisdiction and then they can levy penalty under IGST. And there are 2 or 3 judgments which I have not remembered the exact name, but they have upheld the power to levy penalty under Section 129 during the course of movement from one state to another. Although yes, this is still a matter of litigation and matter has not attained finality by Honorable Apex Court.
Okay, I'll just look into that EV bill reference also, the decisions.
Just in extension, maybe it may not be directly related. Sorry to interrupt you, ma'am. Just assuming a taxpayer has a property outside the state. Say I am in the state of Karnataka, I have a property in, say, Himachal Pradesh. Okay, I have let it out, and my P&L shows some income. Whether my Karnataka state officer is empowered to issue notice on me saying that you have not paid the taxes, or you are liable for collecting taxes and so on, or who's exactly empowered? I have not done my registration in the Himachal Pradesh. Ideally, I should have done it, which I have not done, and I have not paid the taxes.
Okay. So is it like you are collecting any tax on that IGST or something? Nothing.
No
No taxes.
It's a
So
noble property, yeah.
So I think the jurisdictional officer of Karnataka will be testing whether there is any levy as such for CGST, SGST, sorry, IGST on that, but they cannot go beyond the state jurisdiction of Karnataka to see whether any leviability is there in Himachal Pradesh. So according to my view, if there is any levy on that income as an IGST, then they can look into those aspects. But leviability of Himachal Pradesh cannot be tested in Karnataka. That is my perspective.
So the collection cannot happen through Karnataka, like the officer cannot collect the taxes, or where does jurisdiction stops? Of course, it's issuing notice. Then what next?
No, correct. He is issuing notice. Yes, his jurisdiction will be to the extent of Karnataka. That's what I'm saying. Or in case if there is any interstate supply has happened from Karnataka, then to that extent, the Karnataka jurisdictional officer has the right to look into that aspect of leviability based on Article 246A also is very clear on that, and 269 is also clear, 286 is also clear. But is there any levy in Himachal Pradesh that cannot be tested by Karnataka jurisdiction? That is my view here.
Just to add to your query, if we go through Section 22, then the person who is making an outward supply from the state, he is required to be registered in that state. And if you go through the definition of location of supplier, then in this case there are 4 conditions which are to be tested. And in the example which you have cited, that a property has been rented in, say, a state of Himachal Pradesh from the person who is residing at the state of Karnataka. So in my opinion, the person who is making a supply of renting of immovable property from Karnataka of the property which is situated in Himachal Pradesh, that goes into the location of supplier where he is normally residing. So that's why the officer in Karnataka might have issued the notices to for the renting of property, because this is now a common consensus. I would not be saying that it has been settled down. Common consensus that if there is only a renting of property which is situated in other state, and other than that there is no other service like supply of food or arranging the amenities, then it is a simple plain vanilla case of renting, and the location of supplier would be the place from where the person is normally residing. And that's why this notice would have been issued by the Karnataka state officer.
Okay.
And he will also have jurisdiction, because one thing is about place of supply being in Himachal Pradesh, that's a different issue. About leviability, that's a different issue.
Yes.
So the ground that is being taken in many cases is that revenue in any case will not come to Karnataka, because it belongs place of supply is in. But that officers of revenue is taking the stand, that's a different argument altogether, where the revenue will go. But the fact is the livability is there, and I'm supposed to collect in the state of Karnataka. That's being held up by the department. The RPG was also sharing. That is also the view taken in the department, by the department in the courts also.
Because the ultimate objective should be revenue collection. See, having
levy, where it is going, because ultimately CGST, if it is collected by Karnataka, CGST collected by Himachal Pradesh, it's the same. So that is one aspect that is being seen into. So that's why they are saying that place of supply may be Himachal Pradesh, but here the levy will come in Karnataka. But again, I'll go back to Annapurna ma'am, because she has a marathon to run. So Annapurna ma'am, I'll just get back to you then.
Yeah.
Over to you, ma'am.
This territorial jurisdiction and these issues are also discussed in some of the council meetings. So anyway, we'll look into that aspect also. So this is a sequence of the different council meetings which have been discussing on this cross empowerment. So I'll be just taking into the each circular, and I'll just try to bring out the gist of that respective circular or council meeting, just to link it with this ARMA decision, how it was background of that council meeting which has been discussed. So the first very important, and this is from the Karnataka authority also has been part of this council meeting, where they have given the certain aspect on this cross empowerment, and they have stated that once the cross empowerment was essential and should extend across the entire value chain of the taxpayers. So they are just trying to say that in case if the one jurisdiction has conducted the audit, say for example, one jurisdiction has completed the proceeding, then that there is no justification to transfer that to the central administration. So adjudication should be carried by the authority who has executed audit, scrutiny, or investigation. And for the administrative convenience, they have brought that, except in the case of intelligence-based actions, where both administrations are empowered, dual control should be avoided in other processes like registration, return filing, scrutiny, audit, appeal. So they are just trying to bring out certain aspect that in case if the one jurisdiction has initiated either by way of audit, scrutiny, then that jurisdiction authority should complete that proceedings, except in the case of intelligence-based action, that is where both the central as well as state authority can look into that aspect. So I think more or less even this principle has been discussed in ARMA decision, where they are trying to say that if one of the authority has completed the initiated, then that authority should be completing that proceedings. And there is no concept of transfer proceedings. Say for example, central authority has already initiated, they just cannot transfer to state, or state has initiated something, they cannot transfer to central unless if there is a requirement that some information has to be given by one authority to the other authority, that can be cooperated, but it is not that it can be just casually transferred between the central authority or the state authority. So that is what the pointers they are trying to bring out in this fifth council meetings. Any other point, sir? Any other thing which we can try to look at? Because this is what I was just trying to look into the gist of that fifth council meetings.
Ma'am, may I come in for a
Yes, sir. Yes, sir. Please, sir.
To my understanding, please correct me if I am wrong. When we say there is a linear jurisdiction for taxpayers, that state authorities have jurisdiction over taxpayers assigned to state and center to state, I can't find anything anywhere which says that linear jurisdiction is there. Rather, subsection 2, section 6, subsection 2, and
हाँ
clause A.
हाँ
When we come to that, where it says that any officer who issues an order under this act shall also issue under the State Act.
हाँ
Okay, that is fine
yes
because he has to pass orders for those
yeah
both
both the acts
CGST and
yes
SGST.
yes
The
sir.
last part of this clause, which says under intimation to the jurisdictional officer of the state. Rather, this conveys that there has to be a separate jurisdiction for both the acts. Otherwise, there was no necessity for having under intimation to the jurisdiction of the state. Jurisdictional officer of the state, if it is the same officer who is exercising powers under both the acts and issuing the orders, then
Yes.
there is no requirement of sending intimation to the jurisdictional act. So there is nothing which says about linear jurisdiction within the act or the rules as such, but it is generally understood. And within this general understanding, this has never been made clear by the council also. And when the discussions were going on for this, then there was this meeting and this famous circular which is there regarding cross empowerment. So it was accepted, yes, there has to be, but let us say for cross empowerment, it should be intelligence-based action, and it is part of that discussion, but never formalized. So
Okay.
is this understanding correct, or there is something more to it?
No, to my reading, it is only, as you have already said, it is only an intimation to the jurisdictional officer. So, yeah,
So if
whenever,
there is no separate jurisdictional
yeah,
officer, then what is to whom this intimation is to be given? If Act says it has to be intimated, so that means there has to be a separate officer under for State Act and a separate officer for Central Act. Rather, this gives power that there is a cross empowerment rather than linear jurisdiction. It is not an exceptional clause that only for cross empowerment the intimation will be given. It is just a straightforward clause which is there.
okay. Or can we read it as a under intimation to the jurisdictional officer as an office, like an assignment of that taxpayer under the respective jurisdiction? So can we, I
That
think,
Gurjit
would be
sir,
only in
actually,
case of cross empowerment. No?
no,
That
no,
would
Gurjit
be
sir,
only in
actually,
case of. Yes, sir.
yeah,
yeah,
Gurjit sir, I had an opportunity to test this particular issue, which is kidding. So I'll just get back to you in, I'll get back in 1 minute. I'm just driving now.
May I suggest that we can carry on with the discussions you
yeah.
were having?
Till
When
he comes,
Arup sir
yes.
comes, we'll come
Yeah,
back to that point
yes,
if
yes,
required,
sure, sir.
rather than waiting like this.
Yes, sure, sir. Then we have in the case of 9th Council meeting on 16/1/2017, where they are saying that both the central and state jurisdiction have jurisdiction over the entire tax base to ensure that proper checks and balance, neither of the administration should be excluded. And Council agreed that both the central and state jurisdiction should be empowered, should be empowered to undertake the intelligence-based enforcement action across the entire value chain. More or less, it is giving the similar thought which is there in 5th Council meeting. and clear division of taxpayers between the central and state administration. And Circular 1/17 is also issued laying the framework of allocation of taxpayer between central and state. I think this circular plays very important role here because they are just trying to say that if the turnover is below 1.5 crore, they are just trying to divide the jurisdiction between the based on turnover basis also, where if the turnover is below 1.5 crore, then 90% jurisdiction will be with the state government and 10% will be with the central government. And turnover above 1.5 crore, it will be between the central government and the state government. So it will be either based on computer based on geographical locations of the taxpayer. So this is giving certain that there is an allocation of powers between the central and states based on the turnover of that taxpayer, and accordingly the jurisdiction is given to both central and state. So indirectly, it is giving a thought that administration is not that if you are assigned to the state, then only the state administration have to assess and adjudicate and investigate your books of accounts. It is not restricted to that. I think they are trying to give the power to both the state government as well as central government. Though you are having your own jurisdiction based on this turnover basis or based on your specific registration, where the administration is given or assignment is given, but still I think that this circular is giving some reference that both the state government and central government has power to do the administration. And in one of the decision, I think in RAM agency decision, they have said that if you are registered under the state jurisdiction and if you are assigned under the state jurisdiction, then only the state jurisdictional officer has a power to administer your as a taxpayer. And if you are registered under or if you are assigned under the central jurisdiction, then only the central jurisdiction has. So I think even that decision we have to wait and see how they are going to take it further. But as on date, the Armour decision and this council meeting and the overall reading, it is giving that both the state government and central government has a power to do the has the jurisdiction to administer the law, and subject to that except that enforcement based action. They have said that if it is initiated, then both the state government and central government has the power to do. If it is not enforcement based action, then I think the respective jurisdiction should look into that. So this is also giving some thought on this 1/17, sir. So any other thought here, like, because somewhere they are trying to allot between the central and state, it gives that both have been given the jurisdiction to look into that specific taxpayer only, except enforcement based action. Is it that we can read from this circular? And even in this 11th council meeting also, they have said that there should be an express or implied bar to prevent the taxpayer from being subject to proceeding before multiple officers. So this is a general thing which they have discussed, not very specific, but the circular is giving some thought on that. And this is the one which has been said that in 22nd council meeting, this they have framed the notification, but it is yet to be approved. This notification is still not approved, though it was discussed on 4th March 2017. And they are trying to say that the notification on cross empowerment under the CGST Act, SGST Act, along with the supplementary instruction, as suggested, they are trying to implement this single interface committee, but still it is yet to be notified. They have given a draft of that notification also in that respective council meeting. And one more thing is the issue of place of supply should be referred to the council, and that all three cross empowerment, that is under CGST, SGST, and IGST, may be taken together in the next council meeting, but till date it has not come out as such. So if notification and cross empowerment are kept in abeyance for want of agreement on IGST Act cross empowerment, the effort to ensure single interface will be vain. So that's the reason they are still not at issued the notification. So, Arpit sir, you have something here because they are trying to add up here IGST Act also along with the CGST Act and SGST Act.
Ma'am, one thing when I was reading Armour Security, I could see that the interpretation of Section 6(1) is yet to be made. What has been discussed in Armour is how the cross empowerment proceedings would take place, but whether there is a entitlement to start a proceeding in absence of a notification, this is yet to be tested by the Honorable Apex Court. Although there are contrary judgment, which are some are favoring the taxpayer and some are favoring the revenue. But in my opinion, that interpretation of Section 6(1) and the placing of the comma before subject to certain condition, then that is yet to be tested by the Honorable Apex Court.
But Pinnacle case, in the case of Kerala High Court, has said notification is not required.
Yes, man, that's what I'm saying, that there are certain favorable judgment and there are certain judgment which are against.
Yeah.
So it is yet to be tested by the Honorable Apex Court that how Section 6(1), and Council has been regularly admitting it, that yes, notification has to be issued, but that notification has still not been issued, and now they are issuing a circular and then a clarification that interpretation of 6(1) is only when the restriction is to be placed, then only notification is required, else notification is not required. So as of now, this is yet to be tested by the Honorable Apex Court. Yes, there are decisions which have given the power, and regarding the IGST, which was I was discussing, that was regarding Section 129 in detention of vehicles.
Yeah, that's what this concept. This is pending still as such. Okay. And I think that is TVL Vardhaman case, na, sir, which is pending before Apex Court.
Yes, ma'am.
So we have to wait and see if there's any. But anyway, but there are different school of thoughts on this, that the notification is not required. But anyway, we'll wait and see like if there is any further development on the TVL Vardhaman case. But there is one more thought here, sir. After this Armour decision, that Section 6 subsection 1 is notification is not required under, because it has brought a certain clarity on the aspect of Section 6 subsection 2. So that is also one more thought, sir, because this Armour is basically stressing on 6 subsection 2 and not on 6 subsection 1. Can we read that also,
Yes.
sir?
Yes. That's what I was saying, that 6(1) has not been discussed and concluded by Honorable Apex Court in case of Armour security.
And 6(2) is also not referring any specific notification or something.
So what they have discussed is only 6(2), not 6(1). That is my opinion, and any further views of the members which we can have on this subject.
Yeah. Okay. Then there is only one notification which we were able to trace it on this, where the central government, where they have the officers which are appointed under this CGST Act are also authorized officer under this CGST Act by way of notification. I think only this is one notification which has come, where they have given the power to the state officer for the refund pertaining matter on under section 54 and 56 as the case may be, but they have restricted that state officer cannot proceed for refund on this IGST on exports or as the case may be. So there is something which has already been implemented by way of notification under 39/2017. So what we can try to understand is this authorization is given only by way of notification. Only for the refund something we are having a notification, but if you see, it is missing for the other officers actually. So this is also one more which is pending and which has to be looked into as such. Why it has come only for refund, and why not it has specified any other restriction or condition for other kind of notification? Because if you read that 6, it says that such notification is a condition precedent and not contingent on condition. So before implementing that administration of law, they have given a notification that, okay, if it is a refund matter on IGST on export, it should be only looked by the proper officer under the CGST Act and not the proper officer under the SGST Act. So this has been come only for refund and it is missing for other issues as such. So this I thought I'll just bring out so that we understand how it is separate from the other aspect. This is also one more aspect.
Ma'am, here regarding this notification, the school of thought which says notification is not required. So that school of thought says this notification came only because there was a restriction for refund under Rule 96, which is the export of goods with payment of tax. So wherever condition has to be imposed, only there the notification will come, and that is why this notification is issued only in one case. That is the school of thought which supports that otherwise a notification is not required. But just Arpit sir was saying that this is still not decided, and council is also, there are draft notifications lying which have not been approved, and council also says notifications. It seems from their discussions that notifications are required, but the school of thought which supports it is not required, and they say it is the notification is issued only where condition was implemented for refund of that 96 is refund of where customs is processing that refund.
Yes,
So
yes.
state officers can't process that
Can't
record.
proceed. Yes, yes. So it's only a thought to see whether notification is required or not. So that's why I brought this notification so that we can differentiate.
Yes, ma'am, very right. Please.
Yes, yes. And then there is one more circular, CBIC circular issued on 5/10. This is also referred in ARMA decision, where they are saying that if there is an ambiguity regarding this enforcement actions which is initiated by central tax officer in case the taxpayer is assigned to the state tax authority, or the initiation of anti-evasion action by this, intelligence action by the state tax officer in case the tax officer is assigned to the central. So this issue is ambiguity is there. So based on this 9th council meeting, they have said that council has agreed that both central and state jurisdictions should be empowered to take intelligence-based enforcement action across the entire value chain of taxpayer, regardless of administration allocation to any authority. And the authority which initiates such action is empowered to complete the entire process of investigation, issuance of SCN, adjudication, recovery, filing of appeal arising out of such action. So I'm just trying to read to just connect with that aspect. And if an officer of the Central Tax Authority initiate intelligence-based enforcement action against a taxpayer administratively assigned to a state tax authority, the officers of the Central Tax Authority should not transfer the said case to the state tax counterpart and would themselves take the case to its logical conclusion. So this aspect I was saying that they should not transfer the case from central to state or state to central based on this circular which has been stated. And similar position would also remain in the case of intelligence-based enforcement action initiated by the officer of the state tax authorities against a taxpayer administrative assigned to a central tax authority. So I think if you're assigned, so though there are few decisions where they say that you cannot do that, but this circular is giving to some extent a clarity that even though you are assigned to a state, but still the central tax authority has power to, based on this intelligence-based enforcement action, they can still initiate the investigation or audit or administration. So that is what we can try to bring out here. And they're also saying that whoever has initiated, they have to conclude it with their logical conclusion. It cannot that they have just initiated and they cannot transfer that to the other jurisdiction. Yes, anybody here? The same circular is given in ARMA decision. They have referred this for concluding their decision actually. And this is also quite lengthy. I'll just take it little simple way. Earlier in this is a circular 31/2018, where the deputy commissioner or assistant commissioner who has been the proper officer under the 74 and superintendent of central tax was assigned as a proper officer for section 73. Then later on, they have removed that power of DCCT, and they have said even the superintendent of central excise, that is central tax, also can carry out the function of 74. So earlier it was given to deputy or assistant commissioner. Then later on, they have given that power to superintendent of central excise. So they have omitted the functions of section 74 from deputy and assistant commissioner. Along with that, they also provided the monetary limit for functions of limits of proper officer. As we all are aware, we refer always that circular 3/17. So that circular has given based on monetary limit. If you are a superintendent, deputy commissioner, additional commissioner, joint commissioner, as the case may be. So they have given the monetary limit. Based on that, they have to issue the notice and they have to do the adjudication. But in many instances, we have seen that even they have issued the notices beyond their monetary limit, and we have tried to question that you cannot adjudicate as it is beyond your monetary limit. But in Karnataka, we don't have any notifications where they have restricted the officer to issue the notice or pass the order based on monetary limit. Whereas central has a specific monetary limit. So that we generally try to test. But so in Karnataka, we have seen that CTO, a small commercial tax officer, will pass the order of 5 crore or 6 crores, as there is no monetary limit as specified. Whereas in central, we have seen that he has to restrict if it is up to 20 lakhs or 30 lakhs, as the case may be. So there is a difference in the monetary limit between the state and the center also. So that also I just would like to add here. And recently, there is a circular which they have added the monetary limit for 74A notices as well as this penalty notices. So somewhere they are trying to give some power to the respective central officer, but we are not finding the similar type of monetary limit circular or notification under the respective state GST Act. So this is also differentiating the functions between the central and the state, as the case may be. Though there are few states where they have issued a monetary limit circular or notification, but in few states it's still not there as such. So we have to rely on the whatever the notification is effective in that date. Then functions relating to this I've already discussed, and show cause notice by DGGI, and it shall be executed by coming state in whose jurisdiction the notice is registered. So this is generally applicable where the DGGI is doing a common, there's a common adjudicating authority also, and DGGI is doing the investigation on the based on pan-India basis. And there are various states where the DGGI is conducting the investigation, and there will be a common adjudicating authority where they have notified the audit coming state. And recently, I think they have tried to identify that common adjudicating authority based on that in that respective state, if there is a highest taxation or if there is a higher turnover, or if it is a principal place of business, then that place of business will become as a place of business for the adjudication, and there it will be notified as a common adjudicating authority. And I think this was notified in 2/17, and there was a specific circular of 239. And recently also there is a circular 250/2025, because earlier this was notified only for the issuance of show cause notice, but there was no clarity on this jurisdiction of revisionary authority or review power or appeal, because if it is in a multiple states, there was a confusion whether the tax who will be the jurisdiction in that respective state. So they have notified that respective principal commissioner will be the revisionary authority, or the respective commissioner appeal or principal commissioner appeal will be the respective appellate authority. So recently, by way of circular 250/2025, they have notified as such. So they are trying to bring out the common adjudicating authority also when it is conducted by the DGGI, and they have notified the audit coming straight in the respective states also. And they are also trying to bring out that if the taxes are more than 5 crores, then it shall be adjudicated by an officer of the rank of additional commissioner or additional director as assigned by the board. So based on tax quantum also, they are trying to assign to the respective DGGI, and they will not be part of this DGGI. They will be independent of this investigation. And in case the show cause notice is issued on similar issues to the noticee and made answerable to different levels of adjudicating authorities within a common state, then it shall be decided by the adjudicating authority having highest amount of tax, including cess. So if it is in Karnataka, Maharashtra, Gujarat, Rajasthan, and they are going to see if it is a common issue in all the 4 states, then they are going to assess where they are having a principal place of business or where it is notified as a common adjudicating authority, and there accordingly they are going to do the adjudication. So this is they are trying to bring out a clarity on this aspect actually, and there is a specific notification and circular also defining who will be the common adjudicating authority and who will be the respective. So that also can be looked into here actually. So to this extent, there is a clarity on this aspect actually. So anything, when we are going to discuss a practical case study, we are definitely going into this look also. If you are having a multiple states and if DGGI has conducted the investigation, how are we going to look that within the state jurisdiction and other state jurisdiction as the case may. So anybody wants to add something here as? Am I audible?
Now I think we can move. I think you have explained in detail. One thing that has been recently clarified is this about the appellate authority. That is where we are facing the issues. In fact, Ashwin is also here on the call. So Ashwin and me, we are discussing. The adjudicating authority is clarified, but appellate authority is not clarified, because of which we are having an issue. I was handling for an oil marketing company, and all the appellate, like wherever we file the appeals, they were saying that it's my jurisdiction. I will hear the matter because it's in my state. So now this clarity is being brought. I think that is one good thing. But about this other part of 5 crores, then it shall be adjudicated by an officer of the rank of additional commissioner. So in some cases, we are seeing that it's being assigned to a joint commissioner also. So that is again a question. So I don't know how that is being handled.
In few of the central jurisdiction notices, we have argued on this monetary limit also, sir. So if we are going to question, then I think it will be continued. So if you are going to question on that, then that can be considered as invalid notice then.
Yes. I think, ma'am, we can. If there are no other questions, then maybe we can move forward. Or
Yeah. Then we have this circular. This is the last circular, I think, before going into this armor. So this is also little important, I found. So whether intelligence-based enforcement action initiated by the central tax officer against, so similar, we have already seen in the earlier circular. So similarly, they have brought out here also. Whether intelligence-based enforcement action initiated by central tax officer against those who are assigned to state tax administration, or whether special notification is required for cross empowerment. So I think this is still pending before the court as such. But anyway, this they are trying to say that they are authorized to be the proper officer for this act, and there is no separate notification is required for exercising the said power. So Section 6, subsection 2B doesn't require any specific notification, as they are registered under both CGST Act and SGST Act. And one more aspect, they are trying to say that if cross empowerment is subject to condition, then notification is required. But as cross empowerment is not subject to condition, then there is no notification as required. So I think this is what they are trying to bring out here. So 6(2)(b) anyway, notification not required, as we have already discussed on this. Now we'll come to this armor. So before going into this armor, I was just trying to understand this while I was reading someone under Section 70, subsection 1. They have also stated that it is also treated as judicial proceeding. So if I read the term in Section 70 today morning while I was reading, I got this doubt. So before going into armor, I thought I'll just ask before discussing on this proceeding. 70 subsection say the word, every such inquiry referred in subsection 1 shall be deemed to be the judicial proceedings within the meaning of 193 and 228. So somewhere it is giving the reference of proceedings, sir. So this was one doubt actually. I was just trying to see, because this aspect is missing in this armor. They have not discussed anywhere on this 70 subsection 2 aspect, where they are trying to say that inquiry is not a proceeding. But somewhere I was just saying that in 70 subsection 2, they have brought the word as proceedings in the section itself. And in one of the decision of 1988 discussion in Anuntala case, they have said that the term proceedings is not restricted to trials in a court, but includes every step in the judicial process, including investigation, inquiries, and hearing. So there's a erstwhile decision which is trying to define the proceedings, though there is no specific definition as such. They are trying to say that it is not restricted to trials in a court, but includes every step in the judicial process, including investigation, inquiries, and hearing. So somewhere they are trying to give the reference of these proceedings even for the inquiry, that is INQUIRY. So somewhere it is referring to section 70 also. So this was my doubt, sir, today morning while I was reading this 70 subsection 2. So I think at the end we will definitely look into that also as a case study. Or
Ma'am,
to add something on this? Yes, sir. Yes, sir. Guruji,
yes,
sir.
ma'am.
Yes.
So regarding subsection 2 of section 70, it just says that the inquiry which is referred in subsection 1 shall be deemed to be a judicial proceeding
Yes.
as per the IPC or as per the BNS, new BNS.
Yes. Yes, sir.
So that is only for the purpose that the summons which are issued, that empowers that the officer in the same manner as the civil courts are empowered.
Yes. Yes.
So in that sense, it will be considered as a judicial proceedings.
Yeah.
It is, to my understanding, it is not to be understood in with reference to the proceedings under the GST Acts.
Yes. So that
It is
is
only the power which is, and the summons are to be issued for inquiry.
Yes, sir. Only I was just trying to connect this 70 subsection 2 with this erstwhile decision, because
Yes,
the
right,
decision
ma'am.
is referring inquiry, and here it is very specific that judicial is only for Indian Penal Code and specific section, and not for the purpose of GST. So that was just trying to bring out that thing. I'll share that
Yes,
decision
yes.
also actually, which I was
Yeah.
just trying. Yeah. Then we'll just try to go to this little, the presentation is little, it has a lot of things here. So just forgive me for that. But trying to bring out all the aspect which is there in the decision, so we can look into the each facts of the case. So basically, this armor is engaged in the providing security services, and they are registered with this Delhi GST authorities. And this proceedings are for the period April 20 to March 21. And the fact of the case was on 18/11/2024, the show cause notice was issued under 73 for non-reconciliation of turnover in return with the e-way bill and excess claim of ITC. So this is the show cause notice which has been issued by the respondent too. And on 16/1/2025, search was conducted under Section 67(2). Panchanama was drawn and summon was issued under Section 70 to 4 directors, requiring them to produce documents. That is done by Respondent 1. And on 23 January 2025, another summon under 70 to one of the director to produce the relevant documents. So that is by the same Respondent 1. So on 24/1/2025, there was again a letter stating that petitioner has already been, the petitioner has filed this, saying that already SCN has been issued by the respondent 2. So there should not be any proceedings by the respondent 1. So that letter has been filed by the petitioner. Then based on this, it has gone to the Delhi High Court. They have approached to the High Court based on this notice, and they have gone to the High Court saying that by way of writ petition, saying that Section 62B is saying that investigation is already done by respondent 2. So, and respondent 1 does not have any jurisdiction. So once it's already been, proceedings are completed by one authority, then there cannot be a further investigation by the second authority. So they have gone to the Delhi High Court and they are trying to refer this petitioner has relied on Vivek Narsaria case of State of Jharkhand dated 2024, wherein the facts are distinguishable as both state and central were conducting the parallel inquiry. So whatever the decision which is referred by the petitioner, that is Armour, is not correct because the facts are different in Vivek Narsaria case, because in Vivek Narsaria case, both were conducting a parallel inquiries as such. So it doesn't goes with the similar fact of the case of Armour. And the issue was they were conducting the parallel inquiries for the reversal of ITC. But in this Armour case, search was not conducted due to pending proceedings on prior to assessment. It was conducted subsequent to events. So here the search was conducted after the show cause notice has been issued by the respondent too. So we cannot say that the facts of Vivek Narsaria will be applicable to Armour case, and accordingly they have dismissed this writ petition on the ground that any proceedings cannot be construed to include search or investigation, and summons are issued only to elicit the informations. So they have tried to dismiss on this ground, and they have tried to stress on the word of any proceedings which is there in Section 6 subsection 2B, and it cannot include search or investigation or summons. As they are only to collect the information and not to do the adjudication. Now let us see how the petitioner has tried to go against this High Court and try to put their submissions before the Honorable Supreme Court. So they are just trying to bring out the reference of Section 6 2B and saying that it prohibits parallel proceedings on the same subject matter. And they are saying that High Court has erroneously held that statutory bar does not apply to the summons. And they have also stated that there is a Section 146 in the GST law, which says that there is a common GSTN portal which is reflecting all the proceedings initiated by the state and central. So state also can see what central are doing the proceedings, and central also can visible what state are doing the proceedings. So both are, there is a common GSTN portal. Practically, whether they are able to access or not, I am not sure, but this is what has been referred in this decision. And they're also saying that they're referring to this principle of cooperative federalism, because federalism is where the powers has been divided between the state government and the central government. So if there is a parallel investigation on the same subject matter, it will runs to the principle of harmony. So they have referred this circular, which we have already discussed. So they are just trying to say that even if your proceedings are on the same subject matter, if it is summons are also issued, it will be deemed as if it is under Section 6 2B and proceedings are there on the same subject matter. So accordingly, it is not within the power of 6 2B. So they cannot initiate the proceedings if already the proceedings has been initiated by the other authority. Now, the very important word they have tried to stress upon is any proceedings which is there in Section 6 2B encompasses all proceedings initiated under the relevant GST enactment. So they are saying that this any proceedings which is there under the 6 2B is also covering all proceedings. So you cannot read as any means specific, it will cover all the proceedings. And they are trying to refer the judgment of KP Salim case, where they are saying that it is within the power of transfer has been confirmed. So they are trying to give the reference of any which is with the administration. So it covers all the proceedings because section 3, 4, 5, 6 is covering all the proceedings. And proper officer refers to any officer assigned with any function under this act. So accordingly, summons are issued without jurisdiction. So they have referred all the contrary view of the different high courts. So this is what the petitioner is trying to give his submissions to the before the Honorable High Court. Then they have referred to a few of the decisions. So before going to that,
Anupama,
Yeah.
just
I think
yes, Arupji.
Yeah, that's what I think. It's even the clock knows. I think that's 10
already
a.m.
10. Oh,
And
sorry. Yeah.
And maybe that's why your network is also having some issue from 10 a.m. only.
No
So
problem.
anyways,
I
ma'am,
couldn't make out it was 10 o'clock. Yeah, yes, sir. Yes.
no. I think one good thing is all the petitioner's contention has been discussed by us. So let us swallow it a bit, and then maybe in one next week we'll have a gap, and then the next week after that we'll have again the part 2 of this. So, but we'll discuss with you and then maybe finalize that. So I think for all the participants, I would like to really express my deep gratitude for joining. Because as a speaker, I know that when we see more numbers as attendees, it gives me more encouragement, and it gives my team also a lot of encouragement for the hard work they do behind the scenes for the PPTs and all. So let's all join and immerse in the discussion. So, Honorable Ma'am, thank you very much. And now to Arpitji for the closing remarks. Venuji has joined. I'm not sure whether Venuji has joined.
And
Unni sir has joined. Unni ji, your remarks, if you can, if you're not driving. But then Unni ji is driving. So, Arpitji, over to you for the final remarks, for your final remarks.
So, thank you, ma'am. And Arupji, on the statement which you made that we would be skipping next week and continuing it in the next week. So we have an opinion poll, and the members are requesting to have the session in continuation. So that is something we have to.
Yes,
we have to decide that what would be the as per the availability of Annapurna, ma'am. So, ma'am,
yeah, that's what
it was really an engaging session from you, and since you have laid down the legislative background and the decision of the Honorable Delhi High Court, then the petitioner's contention. So stage is all now set for the discussion on the decision of armored security. Then somewhere down the line, we are ending on something like a Ekta Kapoor serial, that what next would come. So we have laid down everything, and let's hope that as per availability, we would be fixing the next session, and looking forward to hear from you.
Yes, sir. Thank you so much, sir. Thank you.
Thank you, and have a wonderful weekend ahead. Thank you.
Thank you, sir.